Good afternoon, everyone. Welcome to the Institute of Advanced Legal Studies Information Law and Policy Seminar. The title of the seminar today is Fighting Algorithms, Challenging Automated Government Decision-Making in Comparative Context. And we have two excellent speakers today, a real treat, two for the price of one today. First, I want to tell you a little bit about the format. We have our principal speaker, Yee-Fui, who is going to give a short presentation on the topic, and then we have a discussant, Justice Richard Humphreys, but he has told me that if some interesting questions come in on the chat, that I'm to monitor that and make sure that I interrupt him if there's some interesting questions that come in. So let me introduce our two speakers. Yee-Fui is an associate professor and deputy director of the Australian Centre for Justice Innovation at Monash University. She has had a stellar research career with a number of articles, reports, and a book that's coming out either later this year or next year from Cambridge University Press. Her research centers on strengthening political institutions and enhancing executive accountability. Her work is focused on the regulation and accountability of actors and institutions in the shadows of government. She was a 21-22 Fulbright scholar and undertook research at New York University on the digital welfare state. She is also the author of The Rise of Political Advisors in the Westminster System, a book published in 2018 by Routledge, and Ministerial Advisors in Australia, The Modern Legal Context. I could go on and on and on, but we'd be here all day on her qualifications. Quite an astounding record for someone, if I might say, as a senior citizen who's so young. Our discussant is Mr. Justice Richard Humphreys. He's a judge of the High Court of Ireland. His current assignment is as judge in charge of the Commercial Planning and Environmental List. He is also, together with me, an senior associate research fellow at the Institute of Advanced Legal Studies here in London. Before his appointment to judicial office in 2015, he was a practicing barrister, and prior to that, he worked in government and academia. He holds a doctorate from Trinity College, Dublin, and has published widely on legal issues. So, Yee-Fui, we'll have you start, and then Richard will jump in after your presentation. Thank you very much.
Thanks so much to Susan for that very generous introduction. And thanks to the Institute of Advanced Legal Studies as well for hosting me on my very first sabbatical, which is great. So as Susan said, I'm writing a book at the moment about the automated government decision-making, comparing the UK, US, and Australia. And it's been interesting writing my third book, and I kind of wondered why I agreed to do it, but it has been a character building exercise, and yeah, I'm looking forward to pushing forward with it. So basically, artificial intelligence and machine learning have enabled widespread automation of government decision-making in the UK, US, and Australia. Yet vulnerable populations have been seriously harmed because of the difficulties that they face in challenging automated decisions. In Australia, the Social Security automated system called RoboDebt erroneously identified overpayments deemed to be owed by Social Security beneficiaries. Errors of methodology led to inflated debt calculations for about 600,000 individuals. Desperate people falsely accused of high debts rang the Social Security Agency Centrelink only to be put on hold for 8 hours. These incorrect calculations have led to grave repercussions for vulnerable low socioeconomic debtors, including individuals experiencing severe mental health issues and even suicide. In 2019, the federal court held that the basis for raising debts under the RoboDebt program was irrational and therefore unlawful. Following this, the Australian government agreed to settle a class action on behalf of the 600,000 people affected by the robo-debt scheme for $112 million without any admission of liability. The judge presiding over the case decried the Commonwealth government's handling of its online compliance system as a very sorry chapter in Australian public administration. The Robo-Debt Royal Commission lambasted the scheme as an extraordinary saga of venality, incompetence, and cowardice. All the way across the globe, in Michigan, Republican Governor Rick Snyder, a former venture capitalist who vowed to run government like a business, decided to put into place a new automated social security system. Unemployment agency staff were laid off to achieve cost savings. In their place, a $46 million automated fraud detection system was introduced in 2001, the Michigan Integrated Data Automated System, or MIDAS. MIDAS was programmed to treat any data discrepancies as evidence of illegal conduct and to trigger an automatic default finding against individuals. This program has been a windfall for the Michigan budget line, collecting over $60 million in just 4 years, bringing the state budget back into the green. However, it turned out the AI system had a 93% error rate. As a result, between 2013 to 2015, the system falsely identified more than 40,000 Michigan residents of suspected fraud and seized their tax refund, garnished their wages, and imposed civil penalties 400% the amount the person is owing, plus interest. These people wrongfully lost access to unemployment payments and faced fines as high as $100,000. As a result of being wrongfully accused of unemployment insurance fraud, 1,100 people filed for bankruptcy. They lost their jobs, their homes, and livelihoods. With a quadruple penalty plus interest, people went into significant debts. As their credit ratings plummeted, there was a stain on their record for 7 years. Consequently, they were unable to get jobs, rent houses, buy cars or homes, and a couple of people attempted suicide. In a 2017 settlement, Michigan's unemployment agency agreed to stop using MIDAS's automated functions without human review. The settlement also made the agency reverse and refund certain fraud determinations. In 2022, the Michigan Supreme Court ruled that people in Michigan can sue state agencies for monetary damages for violating their constitutional rights. In the UK, there was the post office scandal where 735 sub-postmasters were wrongfully prosecuted for theft, fraud, and false accounting in their branches between 2000 and 2014. The Post Office Limited, a wholly owned British government company, aggressively pursued these sub-postmasters through the courts, resulting in numerous criminal convictions, at least 4 suicides, some being jailed, including a teenager and a pregnant woman, and many facing bankruptcy and financial ruin. However, none of them had done anything wrong. The Horizon accounting software system designed by Fujitsu had produced incorrect accounting shortfalls due to bugs, errors, and defects in the IT system that had automated the post office network. Widely decried as one of the biggest miscarriages of justice in British history, this multi-million-pound IT disaster has spanned over 20 years and has generated widespread condemnation. A question that immediately arises is, how did things go so wrong in these advanced liberal democracies with their sophisticated bureaucracies and well-developed systems of checks and balances? For each of these large-scale catastrophes to occur, deliberate choices were made at key decision points by elected politicians and civil servants to procure and deploy faulty technology at a large scale on vulnerable populations. Hundreds and thousands of people were harmed for years due to these wrongful and harmful government decisions. These scandals demonstrate the need to more closely scrutinize the regulation of automated decision-making across government, including how the system is designed, how AI technologies are rolled out, and appropriate auditing mechanisms that should be put into place to mitigate any ill effects. My book therefore looks at the legal, political, and managerial controls that are needed to prevent all these large-scale AI disasters from recurring. So in this talk, I will explore the legal challenges to automated government decision-making in the UK, US, and Australia. The litigation comes from different legal angles in each jurisdiction: constitutional due process in the United States, judicial review and human rights in the United Kingdom, and administrative law in Australia. There are three main forms of challenging government AI decision-making: challenges to the input, output, and the use of the data. First, a person challenged by who once affected by an AI decision could challenge the inputs to the decision-making in terms of faulty code and data. The person can argue based on anti-discrimination principles that the data inputted into the AI systems is biased and produces discriminatory outcomes. Another method is to challenge the outputs or the results of the decision-making. If they can show the computer produces decisions that are substantively flawed, and this can be done through challenges based on the rationality of decisions in the UK and Australia, or due process in the US, which considers the relationship between the inputs and outputs of government decision-making. Finally, another avenue is to challenge the use of the data in terms of data sharing and retention. A person can claim privacy protections in the government's use, dissemination, and retention of AI data. So this talk will focus on legal challenges based on rationality. So a major legal avenue for challenging automated government decision-making is based on the concept of rationality. The legal system is predicated upon the assumption that decisions are made by human administrators and are based on the concept of human rationality. Therefore, decisions made by computers that fail this concept of rationality can be subject to legal challenge. The use of AI in welfare in Western jurisdictions has been plagued with problems of inaccurate or irrational determinations. For example, an algorithm used by the Department of Human Services in Arkansas would determine that a foot amputee had no problems with his feet, despite lacking a foot. So there's problems with rationality there. So there are three main areas of concerns in terms of reviewability. So first, what is seen to be constituting a decision in this context? Who is the decision maker? And what are the grounds to challenge the validity of a decision? So first of all, what is a decision? In determining what is a decision, the United Kingdom has adopted the public function approach based on the Data-Fin test, meaning the key issue is whether a body is undertaking a public function, which will make it immaterial whether the decision is undertaken by a human or AI. In the US, the focus is on the impact of the decision-making on individuals, that is, decisions that impact on a person's life, liberty, or property, with a generous interpretation of the term property as encompassing welfare benefits. And this empowers individuals to constitutionally challenge government AI decisions that affect their fundamental rights. This has not been fully tested, but it appears that Australia is interpreting statutory judicial review under the Administrative Decisions Judicial Review Act by reference to the process of decision-making. The majority decision in Comparative requires a decision to involve a process of deliberation. As the dissenting judge noted, this may exclude automated decisions from its ambits, as AI decisions lack a process of deliberation, and this may therefore preclude statutory judicial review of agency decisions. Australian constitutional review under the Section 75(5) of the Constitution hinges on the identity of the decision maker being an officer of the Commonwealth, which may create issues for AI-made decisions where the decision is wholly made by a computer. However, this may potentially be cured by a legislative deeming provision, deeming a decision made by a computer to be made by a minister or senior government official. Therefore, the UK and US have a formulation for judicial review that is conducive to challenging wrongful AI decisions, while Australia's approach may lead to issues in terms of reviewability. The second question is, who is the decision maker in an AI decision? There's always been a presumption that an administrative decision will be made by a human, so there will be a responsible party. In the case of AI-assisted decisions, where technology is used in the process of making the final decision, this will not be an issue because ultimately there'll still be a person at the end who's clearly the decision maker. When it comes to fully automated decisions, however, it becomes less clear. One option is to borrow from the EU General Data Protection Regulation, or GDPR, and only allow for fully automated decisions in certain circumstances, such as where it's necessary to enter into a contract, is authorized by a law that provides sufficient safeguards for the person's data, or is based on the person's explicit consent. A further method of ensuring there's a designated responsible party is by inserting legislative deeming provisions. These are sections in legislation stating that a decision made by AI technology or computer will be deemed to be made by a minister or senior civil servant. Providing a responsible person for AI-made decisions facilitates judicial review and enables accountability over AI decision-making. Finally, there's the question of the comparative grounds of review across the jurisdictions. In Australia in 2009, the basis for raising debts under the robo-debt program was held to be unlawful. In a test case by a debtor subject to a robo-debt, the federal court in consent orders in Amato and Commonwealth held that automated decisions made on the basis of income averaging alone, that is the robo-debt method, were irrational and therefore unlawful. In the case of Prigodich and Commonwealth, the Australian government agreed to settle a class action, as I mentioned before, for $112 million. The Commonwealth government admitted it did not have a proper legal basis to raise, demand, or recover the asserted debts, which were based on income averaging from the tax data. As a result, the court found that the debts issued were ultra-vires, that is beyond power, and unlawfully incurred on applicants on the basis of mistake of law. The Australian court's approach in robo-debt is focused narrowly on the methodology of the decision-making that produced inaccurate debt notice rather than its substantive impacts. And this means that automated decisions made on the basis of different data points might be held to be valid. By contrast, the approach of the UK courts holds greater promise for success in judicial review for vulnerable claimants because it focuses on the merits of the rule and its substantive framework. The UK framework combines domestic judicial review with international human rights conventions incorporated into domestic law. Therefore, in addition to judicial review, the UK courts will consider human rights grounds of the European Convention of Human Rights, ECHR, which adds to the scope of review in terms of anti-discrimination and privacy. And this allows for a broader scope of challenge compared to Australia. In Secretary of State for Work and Pensions and Johnson, the UK Court of Appeal invalidated part of an automated system used to calculate universal credit payments. The automated system did not accommodate for the fact that people who were usually paid their salary on a particular day each month would be paid a different day if the usual payment date falls on a weekend or bank holiday. And this caused major fluctuations in the welfare payments received. The problem impacted a particularly vulnerable group, those who were on low incomes undertaking ad hoc employment. In this case, the plaintiff was a single mother who was at the risk of eviction due to major welfare fluctuations in the welfare payments and lack of cash flow. This led her to borrow money just to purchase food. One of the welfare recipients, who was also a single mother, reported that the system of fluctuating payments led her to go deeper and deeper into debt and she felt so desperate that she attempted suicide twice. The Court of Appeal invalidated the relevant part of the automated process and found the regulations to be irrational and therefore unlawful. This was because the issue had a dire impact on 85,000 vulnerable citizens and led them to suffer consequential financial stress. In addition, the court found that the processing of claims was arbitrary and claimants were not alerted by job center staff about the problems they would face if the end date of their assessment period coincided with the day of the month their salary was paid. Another basis of irrationality was that the system in effect operated to disincentivize work, contrary to the legislative policy. The system created an incentive not to work to receive a stable income or to look for a job where the salary pay date did not coincide with the end of the assessment period, which may take priority over accepting a promotion or higher paying job that makes use of the claimant's skills and educational achievements. Indeed, one of the claimants refused the promotion because of the payment conditions. Therefore, in its decisions, the UK Court of Appeal was willing to consider substantive issue relating to the actual impact of a rigid rule on vulnerable populations and whether the AI rule achieves its policy goals. And this led to the finding in Johnson that the minister's decision met the high bar of being Wensbury unreasonable, that is so unreasonable that no reasonable decision maker would have come to that decision. In the US, automated government decision-making has been successful on the grounds of procedural due process, which considers whether the government has followed proper procedures when it takes away life, liberty, and property. For example, in the case of Michael T. and Bowling No. 2, a group of West Virginians with severe intellectual and developmental disabilities brought an action against the state's Department of Health and Human Resources, challenging the state's reliance on a proprietary algorithm to refuse Medicaid benefits, which was administered by APS, a private company. The district court found that the APS algorithm did not satisfy America's due process requirements, as the government had not provided any information about factors that were incorporated into the algorithm, how each factor was weighted, and the overarching methodology employed. The court also criticized APS for not providing an individualized rationale for the budgets allocated to the plaintiff, making it impossible for the plaintiff to meaningfully challenge the budgets. The court concluded that the APS decision-making process created an unacceptable risk of arbitrary and erroneous deprivation. As a result, the West Virginian government developed a new system containing matrices with clearly identifiable variables that would be publicly available. The court concluded that the new system sufficiently remedied due process flaws and they lifted the injunction. In general, due process claims in the US have been successful on the basis of insufficient notice, explaining why the AI tool's analysis led to this reduction in benefits, which then created the risk of determinations being arbitrary and erroneous. When an algorithm is used in decision-making, US courts have recognized that individuals affected have to be provided with sufficient information about the decision-making process to ensure that the automated decision is accurate. Therefore, it can be seen that automated government decision-making has been successfully challenged by way of judicial review in the UK, US, and Australia. In US, the challenges have been based on procedural factors, such as the level of information provided about the AI systems. By contrast, in Australia and the UK, the substance of the decisions is material. That is, whether the AI decision can be justified. However, the formalistic approach to legal interpretation in Australia that focuses on the process of decision-making is more likely to hamper legal challenges. On the other hand, the UK's broader rights-based approach that considers substantive issues relating to the impact on vulnerable populations and whether the AI rule achieves its policy goals is preferable to enable individual redress. The American concept of due process allows for individuals to prise open the bonnet and obtain details of the AI system. So to sum up, governments in liberal democracies have jumped onto the AI bandwagon. They've been enthusiastic supporters of new technologies and adopters as well. However, the use of automation in government has often been trialed and deployed punitively on the most vulnerable sections of society to predict and punish criminal recidivism, and unemployment fraud, and to automate social security debt notices. It's never used to predict insider trading by the wealthy, for instance. The then UN Special Rapporteur on Extreme Poverty and Human Rights, Professor Philip Alston, warned about the risk of the digital welfare state, where digital data and technologies are used to automate, predict, identify, surveil, detect, target, and punish. In this context, it's time to seize the gauntlet and address one of the most significant problems of our times: how to ensure that automated government decision-making is implemented in a fair, effective, and accountable manner without harming vulnerable citizens. So thank you very much, and I look forward to the discussion.
Well, thank you very much. Richard, just before you start, I want to say that was quite terrifying to hear about what happened to all of those people. So, Richard, good luck, and I'll enjoy hearing your discussion.
Well, thanks very much, Susan, and thanks to you and Daly and IALS generally for setting this up. It's a nice way to spend a lunchtime to dip into a bit of cutting edge research. And can I congratulate Yee-Fui on the chapter in full? I think she's given an excellent overview of it there, but the full chapter is really good. And I wish you the best of luck with the book. Well, look, I suppose the discussant role is a kind of a devil's advocate. So can I start on that theme, Yee-Fui, by saying that your theme is fighting algorithms and challenging algorithmic outcomes. And there is another side to that case. I think you have, of course, made the point that there have been what you call large-scale AI disasters. That's absolutely right. Obviously, anybody would share the deploring of those. But there are also large-scale non-AI disasters fueled by human decision-making, or disasters that result in a combination. I mean, take the climate emergency, for example, has been fueled by technology over the last 200 years, but has it been created by technology, or is the real driver human decision making? So I think rather than, I suppose we have to sort of not unwittingly create the impression that AI is sort of, or automated decision making or machine learning are sort of inherently problematic. There's a huge, obviously, upside to it, which I think you do acknowledge, and I think that needs to be factored in as well to some extent. Just to take the inputs on that front, for example, and now you mentioned, or at least Susan mentioned, your work on ministerial advisors. I was a ministerial advisor before I went to the bar, so it's a long time ago now. It's very much another life, but it does give you a small amount of insight into how systems work or could work. And I suppose one thing that people sometimes complain about, and you to some extent have touched on this in your work, is the lack of transparency in the algorithm that is producing the decision. But the counter argument to that, I think, is that if one is too transparent about the algorithm, then in certain contexts, not all contexts, but in some contexts, it creates a kind of a perverse incentive or an opportunity for people to, so to speak, rig the system, play to the algorithm, much like a student who knows what the test is going to be can just study to the test rather than study the actual subject. So I suppose can I maybe put that on the table, first of all, just as a kind of a slight counter argument? in terms of the other side to algorithmic decision making.
Yeah, sure. So yeah, thanks so much, Richard, for those comments. So certainly there are many upsides to using automated decision making or AI in decision making. So there's of course the efficiency of decision making and the speed and cost savings that might be generated from that. And I'm certainly not saying that governments should not use AI or should not use automation in their decision making. What I'm arguing for is sufficient safeguards to be put into place before all the harms occur. So in terms of risk assessment, auditing, impact assessment, so that the government departments and agencies undertake a reflective process and risk assessment process before deploying the technologies on vulnerable populations. And you're certainly right that human decision makers do have their own issues as well, because like a judge may be grumpier, not you of course, but at certain times of the day, and that might affect their determination. So or what they had for breakfast. So that idea that human decision making can be inconsistent, can be riddled with bias as well. The problem when you interpose AI on top of all of this is that existing biases or inequalities can be amplified because of the scale of the use of technologies. And yeah, it can get rolled out to hundreds and thousands of people. So certainly challenging the algorithms is probably the last resort when things have already gone too wrong. My book's sort of arguing for managerial controls from the beginning for the government agencies and departments to properly audit and consider the design in terms of impact assessment and risk management processes before it gets rolled out. And yeah, I do advocate for transparency, which you did mention. So the UK has a transparency standard that where governments are supposed to put AI tools on this public website, which would be great, right? Except that no one uses it. So because it's a voluntary register, it doesn't have that many AI tools listed on that website. So that suggests that perhaps we need some form of external enforcement if we are to truly have transparency for government algorithms. And I guess then that goes to the level of transparency as well. You talked about this concept of gamesmanship. If we give too much disclosure of the AI rules or source code or so forth, people can game the system and try to cheat the system in some way or commit fraud or something like that. The problem that we have right now is there's just no transparency at all. So not even the basic level of transparency of knowing just how the government is using AI, what types of AI and to what purposes they're being used. So we don't even have that very basic understanding of how much AI is being used in government and how they're deployed. So I would argue that we do need that, at the very least, that basic understanding of what is going on in government. And then, that's what we hear from civil society groups. We're not getting enough information to know what's going on. And then how can we then challenge anything that's wrongful if we don't even know what's happening within government? So we're still at the early stage of not enough transparency, I would argue.
Yeah, I mean, that's a fascinating issue. And just to work backwards through a couple of the points you've made there, not knowing what's going on, you see in a sense, we're kind of at the foothills of the AI revolution, and it won't be very long before the software that makes the automated decisions is so far beyond, in terms of complexity, anything that can be understood or explained, that the sort of transparency that we would traditionally envisage just won't be possible. So now, in one sense, lawyers are very conservative, and I mean, you know, I don't exclude myself from that. You know, my first reaction to the idea of AI in legal decision making was, how could this ever catch on? You know, we need our judges, etc. But if you look at how it's sort of taken over so many other fields of human endeavor, and again, we're still very much at the early stages here, law isn't going to be exempt from that by any stretch of the imagination. And the complexity is so sort of, it's so kind of exponential, to use a kind of a cliche, but I think it's appropriate here, that traditional concepts of transparency just aren't going to apply. Can I just work backwards to another point you mentioned, which was about kind of human bias? And to me, this is one of the big advantages of AI decision making, which is that it removes that kind of subjective bias element from it. It ensures consistency. And inconsistency can happen for all sorts of reasons. Not necessarily bias as we kind of traditionally understand it, you know, a particular, you know, judge has a prejudice against some group or something. That doesn't really kind of emerge in the case law as something that particularly happens in any kind of massively significant identifiable way. But bias in the very kind of soft, more general sense that everybody's kind of finite in terms of their abilities and their perspectives and their prior exposure and work and assumptions and knowledge and information. You mentioned about judges being inconsistent when they, you know, haven't had lunch or something. You know, funny enough, there was this very famous study about Israeli judges that said they made different decisions when they were awaiting their lunch and they were less generous. But there was an attempt to replicate that, which kind of basically discredited it, and that effect didn't replicate. So let me just add that 2 cents of kind of combating disinformation.
Well, we're over the time now, but I think that's a great place to end it, because I can see the Information Law and Policy Center is going to have you both back, because there is going to be years of discussion on this very critical issue. I found the seminar fascinating. Your presentation, Yee-Fui, was just excellent. And Richard, your discussant comments were so, even for someone who's a novice to this area like myself, I learned a great deal. And on behalf of the Institute, I want to thank you both for your presentation and your participation in the work of the Policy Center and in the Institute. So thank you both very much. And we will close the seminar for today. Thank you very, very much to all of you for coming.